In order to have a trusting and therapeutic relationship with your client, you have to protect their confidentiality. They have to be able to know that what they tell you is going to stay within the bounds of your relationship. Otherwise, they won't feel comfortable working on some of those issues. Confidentiality is rooted in the client's right to privacy. It's the core of effective therapy, and we as counselors have an ethical duty to protect communication. Your book gives you a 6-step ethical model for protecting confidentiality rights. Preparation. To inform your clients about the limits of confidentiality, you must know them yourself. We're going to go through that in this chapter very clearly. Do your legal homework. Devise an informed consent document that describes confidentiality in clear language. Tell the clients the truth up front. Inform your clients about the limits of confidentiality. Obtain your client's consent about these limits as part of the professional relationship. Obtain truly informed consent before making a disclosure. Notify your client of a pending legal demand for disclosure that doesn't have his or her consent. Respond ethically to legal matters of disclosure. Notify your client. Limit disclosure to the extent that it is legally possible. Avoid the avoidable breaches of confidentiality. Avoid making unethical exceptions to the confidentiality rule. Establish and maintain policies aimed at protecting confidentiality, such as note-taking. Talk about confidentiality. Dialogue with clients about confidentiality as needed. Teach ethical practice to students so they understand it very clearly also. In order to understand the core of what confidentiality is, you need to understand about privileged communication and privacy. So, your text describes privilege as the client's right to prevent a counselor from revealing confidential communications in a legal proceeding. This does not apply to groups, couples, marital, family, child, and adolescent counseling sessions. In other words, counselors can refuse to answer questions in court or refuse to produce a client's records in court. However, counselors must know what the laws are in their particular state. These laws ensure that personal and sensitive client information will be protected from exposure by therapists in a legal proceeding. You only need to disclose what is necessary and sufficient, and what is specifically requested by the court. In your chapter, it gives you some lawsuits pertaining to this very issue. Read them and you'll see how privileged communication is protected. Keep this in mind. Members of a counseling group can assume that they could be asked to testify in court concerning certain information revealed in the course of a group session. I think that they've made this an exception to confidentiality because it's really difficult to ensure that everybody in a group is going to keep everything confidential. So your clients need to know that. I mean, we make group rules. Anything said here stays here. But legally, you can't ensure the clients that somebody won't say something that's said in a group setting. Statements made in the presence of a third party may not be protected in a court hearing. Both confidentiality and privilege belong to the client, not the counselor. Professionals are obligated to disclose information that is necessary and sufficient when the client requests it, but only the information that is specifically requested, and only to the individual or agencies that are specified by the court. It's a good policy to inform clients about confidentiality and its exceptions from the beginning of the professional relationship. There are special rules that apply to alcohol and drug abuse patients, federal rules that are called 42 CFR Part 2. In order for a substance abuse treatment provider to disclose information, they must have a signed release of information from the client or a unique kind of court order. A subpoena or similar legal mandate must be issued in order to compel disclosure. A response to the subpoena is not permitted under the regulations unless an authorizing court order is entered. The person may not disclose the records in response to the subpoena unless a court of competent jurisdiction enters an authorizing order under these regulations. A court order may be only entered into if the court determines that good cause exists. In your tab 23 and 13, it provides some very specific guidelines for how to handle a court order as a provider. One of the things that it talks about is that there must be other ways of obtaining the information, and if there isn't, then you can issue a court order. They've tried everything else, and this is the only way to get the information that they need. The public interest and the need for this information or this disclosure outweighs how this information may be harmful or a potential injury to the patient. In other words, getting this information is much more critical than what might happen to the client if the information is exposed. We need to limit those parts of the court order that are absolutely essential to fulfill the objective of the court order. When you are looking at the court order, you really still want to keep in mind that you want to protect your patient and the therapeutic relationship as much as possible. So if you have to disclose some information, maybe ensuring things like sealing the record from public scrutiny, things like that, in order to protect your client as much as you possibly can. Privacy refers to the constitutional right of an individual to decide the time, place, manner, and extent of sharing oneself with others. You must not reveal identifying information about clients orally or in writing, or even the fact that they consult with you without their formal consent. This includes even talking to their employers, so be very careful. Telecommunication devices can pose potential ethical problems. Your chapter offers these guidelines for counselors using the telephone. Don't acknowledge that the clients are receiving services or give out information regarding clients to unknown callers. In other words, you should say, I can confirm or deny that I even know that person. Strive to verify that you're actually talking to the intended person when you make or receive calls in which confidential information will be discussed. Be aware that there's no way to protect your conversation from being recorded or monitored by an unintended person. Be professional, brief, and very careful in talking about confidential information over the telephone. Avoid making any comments that you would not want your client to hear, or that you would not want to repeat in a legal proceeding. Other issues to discuss with the client concerning their privacy include interactions away from the office. In other words, hey, when I see you out in public, I'm not going to come up and talk to you because maybe who you're with doesn't know you're in counseling. So I'm going to leave it up to you. If you want to say hi, I'll be happy to respond, but you will make the first move. No genuine therapy can occur unless the clients trust what they say is confidential. They need to know that you're protecting that. When it does become necessary to break confidentiality, it's good practice to inform the client of the intention to take this action and to let them be part of the process if possible. All major professional organizations have taken the position that counselors must reveal certain information when there is serious and foreseeable danger to an individual or to society. I think you have an ethical obligation to absolutely memorize what the exceptions are to confidentiality. One of the exceptions is when the client gives consent, like in a release of information. When there's reimbursement, like with insurance companies or billings, or legal issues, court orders, then you can be required to disclose. clerical assistants handle confidential information and have to deal with people like managed care. You can work with managed care and again other insurance companies, and that would be considered an exception to confidentiality. We know that the counselors often consult with experts or peers. And when your counselor is working under supervision and they need to discuss the case, that would be an exception also. However, your peers and your supervisor absolutely know that they need to protect the client's confidentiality also. When other mental health professionals request information and the client gives consent to share, now remember, that's the key word there. You can't just give this information out. The client has to allow you to do so, usually with a release of information. Other professionals are involved in a treatment team, like staff meetings. Then we know that your case may be discussed. Now we know that there are some legally mandated exceptions, meaning by law you have to break confidentiality. The two big ones that we're most familiar with is obviously the statutes involving child or elderly abuse. If you know that's happening, you have to disclose it, and that's something that you would tell your clients in informed consent. Or the other one is if the client poses a danger to themselves or others. We know that you can't sit on that one. You have to do something about it. So some of the other exceptions are when there is the disclosure is court-ordered. We talked about that a little bit earlier in CFR 42. When the client waives their privilege, you have to know that when a client files complaints against their counselor, the counselor has an absolute right to be able to address that and can violate confidentiality to protect themselves. If the client claims psychological damage in a lawsuit, again, you have a right to defend yourself in a lawsuit. Civil commitment proceedings are initiated. You may need to testify and provide information regarding your work with the client in order for the court to make an absolute decision. Be familiar with not only the legally but other exceptions to breaking confidentiality, and be sure again that you're discussing this information with your clients right up front and throughout the process, especially in an informed consent.